Hello, my name is attorney Ramsey Bahrawy, and welcome to Your Money, Your Life, a show dedicated to educating you, our viewers, on the importance of planning. This is the third segment of a program discussing the unique challenges baby boomers face as their parents age. In the first segment, I primarily focused on housing, transportation, and elder care issues. In the second segment, I discussed estate planning issues. In this segment, I'll focus my discussion primarily on financial and tax planning issues. Some things seem like they should be easy, and they are easy. However, some things simply appear easy, even when they're very difficult. The problem with some complex responsibilities is they may seem simple on the surface, yet they may be very difficult in reality. For example, crossing a short field may seem simple, right? However, if that field is a minefield, it might be a very hazardous crossing indeed. On the surface, both fields might appear the same to the ordinary person. However, experts can spot the hidden problems, which the ordinary person may not. When it comes to financial and estate planning, successfully navigating minefields is crucial. Minefields such as the status of the estate and gift tax laws, investment options, asset protection rules, trust rules, insurance options, reverse mortgage issues, and probate issues. In this regard, it is important for boomers to recognize that no one knows what the future will bring. No one has a crystal ball. In other words, tomorrow is not promised to you. By the same token, no one wakes up one morning thinking, gee, today I need to talk to mom and dad about their need for financial planning and asset protection. First, let me briefly talk about financial advisors. By and large, financial advisors focus on helping families save for their children's college educations, manage cash flow, and prepare for retirement. Financial advisors play an important role. They have knowledge of the process, the techniques, best practices, tools, and possible alternatives. A financial advisor's role is to accomplish your objectives with the most effective use of resources while weighing your tolerance for risk and considering your time horizon. With the assistance of a financial advisor, one should be able to set achievable financial goals, develop a realistic, comprehensive plan to meet one's financial goals, and avoid serious investment mistakes. However, since today's complex and burdensome healthcare system can so quickly and radically diminish assets, there is a real need for financial planners who are experienced in long-term care planning and can guide their clients in making the complex post-age 65 life decisions. It's legally well established that parents have a responsibility to financially support their children. However, did you know that approximately 30 states have enacted laws requiring children to be legally responsible to support their parents? These laws are called Filial Responsibility laws, and they vary from state to state. Massachusetts enacted a Filial Responsibility statute. It can be found in Chapter 273, Section 20 of the Massachusetts General Laws. Generally speaking, in a state having filial responsibility laws, a nursing home may seek reimbursement from the resident's children, as these laws hold adult children responsible for the financial support of indigent parents and, in some cases, their medical and nursing home costs. The Massachusetts statute states in part, any person over age 18 who, being possessed of sufficient means, unreasonably neglects or refuses to provide for the support and maintenance of his parent, whether father or mother, residing in the Commonwealth, when such parent through misfortune and without fault of his own is destitute of means and is unable by reason of old age, infirmity, or illness to support and maintain himself. Typically, filial responsibility laws aren't enforced unless your parent has to accept financial support from the government or incurs a nursing home or other medical bill that he or she has no possibility of paying. If your parent has no financial resources, you might be expected to pay for that care. In states with filial responsibility laws, the nursing home, hospital, government, or a third party may be able to file a lawsuit against the child. In so doing, these third parties would seek a judgment that would obligate the child to pay his parent's bill. Most state laws specify that your parents must be indigent before the court will rule in favor of a filial responsibility lawsuit. The Massachusetts law is more specific, stating that parents must be destitute by reason of old age, infirmity, or illness, and unable to support and maintain himself or herself. The penalty under the Massachusetts statute includes a fine and a jail sentence. Other states may allow garnishment of wages or a lien against the child's property. At this juncture, there are some important points for me to make regarding filial responsibility laws. First, a filial responsibility law is unlikely to hold a child responsible who's struggling financially. Second, a filial responsibility law is unlikely to hold a child responsible who is paying significant costs for his own child, such as college tuition. Also, if your parent abused you or abandoned you as a child, the parent is undeserving of your financial support. Lastly, the filial responsibility laws do not apply to an older adult who has gifted assets and satisfied the 5-year look-back. Therefore, one protection is to meet with an elder law attorney and develop a plan that would comply with Medicaid regulations and assist a parent in qualifying for Medicaid while protecting assets. I am well aware that many aging parents of boomers resent and resist having adult children discuss their financial situation. But the new reality is that adult children do have the responsibility and right to clarify their parents' financial matters. As filial responsibility laws vary from state to state and those laws are complicated, this discussion only provides a brief general introduction of the topic. For more detailed specific information, please contact an elder law attorney or consult Chapter 273, Section 20 of the Massachusetts General Laws. Another important tool in your parents' financial toolbox is long-term care insurance. Since long-term care insurance is both complicated and costly, invest the time to learn how such insurance policies work. Like other forms of insurance, long-term care insurance takes into consideration risk factors such as your age and health history. Once you have learned how long-term care insurance works, ask some simple and straightforward questions. How old are you? What type of lifestyle do you live? Does your family have longevity in its genes? What is your family health history? Can you afford to make uninterrupted long-term care insurance premiums to assure a reasonable amount of coverage? Will you have the financial ability to pay for care from your own assets? What is the insurance company's history of paying claims? Also be aware that insurance companies such as Prudential, MetLife, John Hancock, and UNUM are either exiting the long-term care insurance market or severely limiting their policies. This is happening because long-term care policies aren't profitable to the insurance companies. This is so for two reasons. The first reason is low interest rates. The second reason is that many more people are using their long-term care benefits today. The second reason should be ample evidence that we all need to prepare for long-term care costs. Having said that, I will share with you what I see as some pros and cons when buying a long-term care insurance policy. Although my list of pros is very short, it can be very compelling. In my view, the most powerful argument for purchasing a long-term care insurance policy is that long-term care expenses can wipe out your retirement savings, whereas insurance properly purchased can help avoid this from happening. Also, a long-term care policy can significantly reduce the burden on family and friends. Now for the cons. The annual policy premiums are expensive. If you purchase a policy in your 50s, the annual premiums can range from $1,000 to $3,000 or more per person. The cost depends on the policy's features. Another con is that these insurance policies are confusing. Their terms and features vary widely from when benefits start and the maximum daily payout to how long benefits last and what services are covered. To avoid any surprises, reading the fine print is a must. For example, a policy may not cover all health conditions or all types of long-term care services and facilities. Also, some policies have strict eligibility conditions for paying benefits. If you don't meet these conditions, you might be incurring long-term care expenses but won't receive any benefits from your policy. Another potential downside may occur after people retire. Here's a possible scenario. A person purchases a long-term care insurance policy while he is working, but in retirement allows the policy to lapse as he no longer can afford the premiums. If you're considering a long-term care insurance policy, understand that some medical conditions make having such an insurance policy more important than others. Therefore, if you have a family health history of Alzheimer's disease, stroke, or multiple sclerosis, a long-term care insurance policy may be appropriate, since you likely would need full-time care for an extended period of time. On the other hand, if you never need long-term care, the money spent on premiums may seem wasted. However, by owning a long-term care policy, you enjoy the peace of mind that comes with insurance protection. Your alternatives are to self-insure, invest in a hybrid annuity with a long-term care benefit, or engage in asset protection. Self-insuring only works if you have the funds to pay for the care without substantially reducing your lifestyle. Of course, the wild card in self-insuring is knowing the dollar amount needed for future care. The major benefit of self-insuring is that you save money on the premiums. The major disadvantage of self-insuring is that you have to pay for your long-term care completely out of pocket and at private pay rates. Therefore, self-insurance works best for people who may only need care for the short term. Another alternative is a hybrid annuity. This type of investment vehicle is a tax-deferred annuity with a long-term care benefit. The hybrid annuity can be used for retirement income or long-term care. The benefit of this type of annuity is flexibility. In other words, you can use the funds for more than one purpose. Also, such an annuity may have tax advantages. The bottom line is that middle-class Americans will need to plan for an age-related disability and illness. That may involve requiring help with cooking, cleaning, bathing, and dressing. This assistance may be at home or in assisted living. It may also involve dementia care. Now let's talk about reverse mortgages. A reverse mortgage can be a useful tool for retirement planning. However, before entering into such an arrangement, you need to understand how a reverse mortgage works. In brief, when you take out a reverse mortgage, you will own the property subject to the reverse mortgage during your lifetime. Here are 10 important points you need to know about reverse mortgages. First, a reverse mortgage is also called a home equity conversion mortgage. Second, to obtain a reverse mortgage, the borrower must be at least 62 and the home must be owned outright. If the home has an existing mortgage, it must be paid off with the reverse mortgage. Third, the real estate must be the borrower's primary residence, and the home must meet certain housing and urban development department standards, such as having the necessary fixtures that make it habitable. Fourth, a reverse mortgage can be taken on a single-family home, some condominiums, modular homes, and some duplexes. Fifth, the law requires that a borrower see a reverse mortgage counselor before applying for the mortgage. The borrower is responsible to pay for the fee for this session. Sixth, regardless of the terms of the reverse mortgage, a borrower will never have to make a payment or pay off the loan as long as the borrower or a surviving spouse occupies the property as a primary residence. It is important to understand that although the borrower does not make any monthly payment of interest and principal on a reverse mortgage loan, interest accrues until the loan is paid off. Seventh, unlike standard home loans, you must have the financial ability to pay your real estate taxes, homeowners insurance, and homeowners association fees. Eighth, when a borrower is approved for a reverse mortgage, the borrower may receive the money in a lump sum, as a line of credit, or in monthly payments to the borrower. However, please note, if the borrower elects installment payments, the amount of each installment payment is affected by the term of the loan. Ninth, The amount of the reverse mortgage loan depends on the equity available under certain guidelines. And 10th, as with other home loans, there are substantial fees, loan origination fees, closing costs, interest, mortgage premium fees, and FHA insurance. To justify these costs, the loan needs to be of a long-term duration. Please understand that there are 5 circumstances that render a reverse mortgage loan due and payable. They are: first, the death of the borrower; second, the home is sold prior to the borrower's death; third, the home is no longer the borrower's primary residence; fourth, failing to pay real estate taxes or hazard insurance; and fifth, allowing the property to deteriorate. If the property is sold to the extent that the sale proceeds exceed the amount required to repay the loan, the borrower or the borrower's estate keeps the surplus. In conclusion, in a reverse mortgage, the borrower basically swaps equity in the real estate for a lump sum of cash or a line of credit or monthly payments. Instead of writing a check to the bank each month, the process works in reverse. The bank pays the homeowner. There is no credit or income requirement in order to qualify. The only requirements are age and equity. On an FHA reverse mortgage, a borrower can never owe more than the home's value. Although a reverse mortgage can help an older adult overcome financial difficulties, this type of loan isn't for everyone. I believe it is prudent to consider alternatives such as selling the home and purchasing a smaller one, renting out a room, adjusting expenses, or selling an insurance policy by way of a life settlement. Now let's talk about what I will euphemistically call family issues. Every family has its own dynamic in which it develops issues that can create conflict and discord. As a lawyer who has significant civil litigation experience, I can tell you that conflict is the root cause of litigation. Another way to say this is that without conflict, there can be no litigation. Unfortunately, something as simple as adding a child's name to a bank account can set the stage for a significant legal battle after the parent's death, especially since mom or dad won't be around to answer questions or referee the dispute. Did mom put Jane's name on her bank account because she wanted her to be able to withdraw funds while she was living? Or did she intend that Jane inherit the account when she died? Or rather, did mom intend to give Jane access to the money just in case something happened to her, with the intent that upon her death, all of her children would evenly divide the account? Often siblings just don't get along. They may still be engaging in sibling rivalry, or may still have unresolved childhood conflicts, or may suffer from jealousy, or may simply be greedy. Every family has some amount of tension percolating just beneath the surface. And this tension is heightened as siblings address family inheritance issues. Now just imagine the fight that ensues when mom or dad is no longer around to referee. In litigation, ambiguity and conflict are the mother's milk of estate conflicts. The conduct we interpret as greed or pettiness in a will contest may actually be a symptom of unresolved family issues. When a parent perceives unresolved family conflict, it's important to set up an estate and financial plan that avoids a perceived slight, lack of approval, or love. Although it is the job of a litigator to sue, an estate planning attorney tries to keep clients out of court. Therefore, estate planning attorneys are aware that ambiguities, uncertain language, undue influence, lack of mental capacity, and improper signature or witnessing of a will can result in litigation. Litigation over these issues can result in unintended consequences. Legal disputes can arise when one does not have a will, power of attorney, and healthcare proxy. If you don't have these basic documents, the government controls where your property goes and monitors who makes decisions about your health care and your funds. If you become incapacitated, a judge will appoint a guardian and conservator to take care of your financial and medical affairs. Families often disagree over who will serve in these roles, and these conflicts often end up in court. These cases can be brutal, costly, and time-consuming. The types of estate plans that guarantee that a family member will race to consult with a lawyer are those that singles out an heir, disinherits children, or leaves the entire estate to the dog. In other words, plans that seem irrational or flippant or leave much room for doubt and speculation. They are a litigator's delight. Baby boomers are now or soon will be part of the senior generation. Those baby boomers who are fast approaching retirement age should plan and document their wishes. This should not be considered as a depressing event, but rather as a smart way to plan for your old age and death. In so doing, you will save yourself and your family a large amount of grief and heartache. Work with a team of experienced CPAs, financial planners, and estate planning lawyers. Such a team will help enhance your future security. These professionals can guide you in making the best legal and financial decisions during your lifetime to ensure the well-being of your family. Also, this team of professionals will ensure that your plan is designed to meet your unique needs and goals, while also preserving family traditions and beliefs. Once, with the help of these professionals, you've created your estate and financial plan, make sure to have it reviewed on a regular basis by this team. It is this review that ensures it's up to date and accounts for any changes in your life or current law. I never cease to be amazed by the elaborate schemes that my clients will hatch. Here's an example. Several years ago, I met with a gentleman whom I will call John to discuss different planning concepts. John had a level of wealth that justified tax planning. After our meeting, he went home to discuss the various concepts with his wife. About 8 weeks later, I met with John and his wife. As John walked into my conference room, he exclaimed, "I know exactly what I want. I want all my assets to go to my wife tax-free. And if my wife remarries or has a boyfriend, I want the trust to limit her access to my assets." In other words, John wanted to be sure that his money went to his children tax-free and not to his wife's new husband. But if John needed nursing home care, he wanted his trust set up in such a way that the government would pay for his care. In addition, John wanted to retain full control. Then John looked me straight in the eye and said, "And of course, I need you to keep it simple." My answer was short and sweet. "John, now that I understand your goals, I don't believe you need a lawyer, but rather a magician." John clearly wanted his cake and eat it too. As I alluded to earlier, a comprehensive estate and financial plan has several important components. To some, planning may seem like a daunting task. However, it is easier to handle if you break it down into 3 component parts. They are: first, developing a plan for the rest of your life. Second, protecting assets in the event of an age-related disability or other unanticipated event. And third, protecting your family by engaging in asset protection or estate tax planning. Boomers and their parents need to recognize that there is a need to plan for the rest of their lives. The planning that is done depends on their particular circumstances. If you are likely to suffer from an age-related disability, you need to plan for that event. At the end of the day, nobody has a crystal ball to predict the future with any kind of accuracy. When the inevitable catastrophic event occurs, such as cancer, a stroke, Alzheimer's disease, or age-related disability, only then do people understand the importance of planning well in advance. It is then that they recognize that planning in both financial and emotional sense has real value. Powers of attorney, healthcare proxies, and asset protection are suddenly perceived as crucial. Given that there likely will be changes to Social Security, Medicare, Medicaid, and the estate tax laws, baby boomers and their parents need to tackle 3 major issues. Number 1, retirement. Number 2, elder care. And number 3, estate planning. Given the wonders of modern medicine, they will need to learn how to plan for their retirement while also learning safe ways to spend down their money in retirement. They will also need to anticipate their healthcare expenses as they age. They need to educate themselves on properly protecting themselves and their assets using medical and long-term care insurance. As the poor economy has shaken most middle-class families, many baby boomers are struggling to keep themselves whole. Some are still caring for children, sometimes adult children who have come back home. Boomers will be challenged trying to help their aging parents. Moreover, the boomers should learn a lesson from this experience and make sure they are not in the same position later in life with their children. If you establish a living trust because of the flexibility it provides in distributing assets, make sure that your financial advisor properly funds that trust so that your assets are distributed by the trust according to your wishes. For example, you could direct your living trust to disperse assets to children or grandchildren at specific ages. A trust allows assets to be distributed without going through the time-consuming and public probate process. It's essential that you let your family know about the existence of the trust and just how assets will be distributed and to whom. Depending on the size of your estate, your heirs may never have to worry about estate taxes. But that's hard to predict, especially given the fact that federal estate laws have gone through several changes in recent years and may do so again. Your best bet is to stay informed about the exemption level, the amount you can pass on to your heirs, free of estate taxes, and look for ways to reduce the size of your taxable estate. You could, for instance, make charitable gifts, thus moving these assets from your estate. You may also want to consider arrangements such as an irrevocable life insurance trust, under which you can transfer a life insurance policy out of your estate and have the trust distribute the proceeds to the beneficiaries you've chosen. Or a credit shelter trust, which allows both you and your spouse to take full advantage of both your estate tax exemptions. Remember, a well-done financial and estate plan includes not only properly prepared legal documents, but also the need to properly own your assets and have proper beneficiary designations. It is of key importance that assets are owned and beneficiary designations are handled properly. Also, both the financial and estate plan, including asset ownership, should be periodically reviewed with an eye to your changing circumstances and changes in the law. The failure to take these steps can lead to 4 unintended results. The first, the wrong party ultimately receiving your assets after your death. The second, the loss of various tax and asset protection benefits by failing to take advantage of the benefits of a trust built into your estate planning documents. Third, the loss of income tax deferral benefits from an inappropriate beneficiary designation on your IRA and qualified plan. And fourth, the loss of assets to creditors over your intended beneficiaries where your economic circumstances have worsened. When deciding how to own your assets and as to the most appropriate beneficiary designation, you should consider the following 5 factors. First, funding the plan set out in your estate planning documents. Second, providing needed liquidity to enable the plan to be carried out smoothly. Third, tax benefits. Fourth, asset protection benefits. And fifth, risk of a future divorce. These decisions are not always easy to make since different factors may provide you with different answers. But the key is to consciously consider the factors and decide what is right for you in your given situation. If it's one thing boomers know, it's that life doesn't stand still. And neither should your planning. It is by working with a competent estate planning attorney and financial planner that one can implement a goal-oriented strategy to realize peace of mind. In closing, the essential lesson here is don't procrastinate. Ensure your affairs and those of your parents are in order. This will create comfort as well as peace of mind. The trick is to live for today and be prepared for tomorrow. In so doing, you will have less worry and more personal fulfillment. That is our show for this segment of Your Money, Your Life. My name is Attorney Ramsey Bahrawy.